Hello, I'm Keith Hockton, author, historian, and host of Rearview Mirror Chronicles, where we take a look back at the people and the moments that shaped our world through history. Hello. Here's a strange fact to sit with before we start. The document most Americans picture when they hear the word freedom isn't the Constitution itself. It's 10 short amendments bolted into the end of it. And they were written almost as an afterthought. And they were written by a man who'd spent years arguing that they weren't even necessary. That man was James Madison. The amendments are the Bill of Rights. Without them, there's a real chance that the United States never gets off the ground at all. Several states only agreed to ratify the Constitution because they were promised this list would follow. No promise, quite possibly no country. So today we're going to look at how 10 amendments written in a hurry as a political compromise nobody was fully happy with, if we're honest, became the most quoted, most fought over, and arguably most loved part of the entire American legal system. So where did we leave off from part 2? Last time we walked through the Constitution itself, ratified in 1789, and it split power 3 ways. It set up a machine for actually running a country, but if you were listening closely, you'll also remember something, something curious. The original 1787 document didn't contain a list of individual rights. No guaranteed free speech. No guaranteed trial by jury. Nothing written down promising the government wouldn't search your house whenever it felt like it. That absence was an oversight. It was a deliberate choice and a very controversial one. And it's exactly where today's story begins. I think it was a fight that nobody expected to win. When the Constitution went out to the states for ratification, it ran straight into a wall of suspicion. 2 camps formed almost immediately. On one side sat the Federalists, men like Alexander Hamilton, and he argued that listing rights wasn't just unnecessary. It was actually potentially dangerous. And the logic went something like this. The federal government only had the powers specifically written down for it. If it wasn't given the power to restrict your speech, it simply couldn't restrict your speech. So why write out a list at all? Hamilton, of course, went further. He warned that listing certain rights might actually backfire. Future governments could look at that list and quietly conclude that everything left off, well, it wasn't protected at all. Leave something out, and you've handed a future tyrant an excuse. Look, I think it's a very clever argument. It's also one that lost, and lost very badly, in the court of public opinion. On the other side stood the anti-federalists, men like Patrick Henry and George Mason. Well, they weren't in a trusting mood. They just fought a war against a government they believed had trampled their rights. They weren't about to hand sweeping new powers to another government on nothing but a promise of good behavior. Vague assurances that rights were implied, well, it simply wasn't good enough for them. They wanted rights spelled out in black and white when no future official could pretend not to see them. Several states actually made their position very blunt. Ratify, yes, but only if a Bill of Rights follows immediately afterward. Virginia, Massachusetts, and New York all attached some version of that condition. The Constitution scraped through ratification, like literally scraped through, but the debt was already on the books. Somebody was going to have to pay for it. That somebody, awkwardly enough, turned out to be James Madison, the same man who'd spent the ratification fight arguing the whole idea was pointless. And to some extent, he was a reluctant author. Here's where the story gets genuinely interesting. Madison didn't come around out of, kind of sudden philosophical conviction. He came around because he was staring down a very specific political threat. Patrick Henry was still furious about the Constitution. He was maneuvering to keep Madison out of the very first Congress altogether. Worse, From Madison's point of view, Henry was pushing hard for a full second constitutional convention. And that could have unpicked the whole document Madison had just spent years building. Madison desperately needed to outflank him. So in 1789, newly elected to the House of Representatives, Madison sat down and did the thing he'd argued for years was unnecessary. He drafted a list of amendments himself. He worked through dozens of proposals that had been sent in by the state ratifying conventions and narrowed them into something incredibly workable. Congress, of course, trimmed his list further still. 12 amendments went out to the states for ratification. Only 10 came back approved. And on the 15th of December, 1971, those 10 are the ones that we now call the Bill of Rights. The document Americans treat today as sacred, practically handed down from on high, was in large part the work of a man talked into it by political survival instincts, not conviction. Madison himself put it rather plainly. He privately called the amendments a nauseous project. Something that he pursued, I think, mainly to calm public anxiety and to take the wind out of his opponent's sails. And you know what? It worked exactly as he intended. It just wasn't born from the reverence, that we now attach to it. So what do the 10 amendments actually say? What did Madison and Congress actually produce? So let's walk through it, because most people can name maybe 2 or 3 of these amendments and have never really sat and considered the rest. The first amendment is the one people reach for most often. It's doing an enormous amount of work in a single sentence. It actually protects freedom of religion, freedom of speech, freedom of the press, the right to assemble, and the right to petition the government. And many historians actually treat it as the cornerstone of the entire American democratic project. It's the amendment that makes all the others possible. A country where citizens can't speak, organize, or worship freely, well, let's face it, it has a much harder time of defending any of its other rights either. It's tempting also, I think, to assume that the amendments that follow keep pace with the first, each one just as urgent as the last. History didn't organize itself so tidily. The Second Amendment reads word for word, and I'll quote here, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." So that single sentence has probably generated more modern argument than any other 18 words in American law. Does it protect an individual's right to own a firearm, full stop? Or was it primarily about states being able to maintain their own militias, a very different concern in a country that had just fought off a standing army it didn't control? The National Rifle Association has long championed the individual rights reading. Others point out that an 18th century musket and a modern assault rifle share little beyond the name firearm. And look, I want to come back to that because it hasn't gone anywhere. Interestingly, the Third Amendment is almost forgotten today, while the Second actually dominates the headlines. Yet in 1791, the opposite would probably have been true. The Third Amendment actually bars the government from forcing soldiers into private homes. And it's barely discussed today, mostly because it's barely relevant today. But it wasn't written in a vacuum. Quartering troops in private homes was exactly the kind of thing colonists had lived through under British rule. So this amendment is a quiet reminder of just how personally that grievance was once felt. There's a close cousin to that grievance right next door, one that grew out of the same colonial memory of soldiers and officials letting themselves in uninvited, and that never really faded from relevance the way the Third did. The Fourth Amendment protects against unreasonable searches and seizures. And look, it generally requires a warrant, rightfully so, based on probable cause, before the government can do any digging through your property. This one has aged in I think, a very genuinely strange way. It was written for a world of physical papers and locked doors. It's now the amendment doing the heaviest lifting around mobile phones, cloud storage, GPS tracking, and of course, facial recognition technologies. And the framers could never have begun to imagine anything like that, and certainly being interpreted through a language that was written in 1791. Once the government has gotten past your door, the amendment governs what it can do once you're accused of something. The Fifth Amendment is arguably America's most famous legal protection, the one that gave popular culture the phrase, "I plead the Fifth." And how many times have we heard that recently? But what it does do is guarantee due process. It protects against self-incrimination and double jeopardy, meaning that you can't be tried twice for the same crime. And it actually requires the government to compensate you if it takes your property for public use. The Fifth protects you in the run-up to a trial. The next two govern what happens once you're actually in the courtroom. So the Sixth Amendment guarantees a speedy public trial and an impartial jury, the right to legal representation, and the right to confront the witnesses testifying against you. The Seventh Amendment extends jury trial protection into many civil lawsuits too, not just criminal ones. And that's an important thing to note. And once a trial ends in conviction, one amendment alone governs what the state is allowed to do next. The Eighth Amendment prohibits excessive bail, excessive fines, and cruel and unusual punishment. A phrase that's driven modern arguments over solitary confinement, prison conditions, and of course, capital punishment. Then come the two amendments most people never really sat with. And I think they might be the most conceptually interesting of all 10. The Ninth Amendment says, in effect, that just because a right isn't listed here doesn't mean it doesn't exist. And if you think about it, it's a safety valve. It's an acknowledgement that 10 amendments could never possibly capture every right a free citizen might reasonably hold. It becomes central, doesn't it, to modern arguments over privacy and other rights the Constitution never explicitly names. Where the Ninth guards against rights nobody thought to write down, its partner guards against power nobody thought to hand over. The 10th Amendment closes things out by stating that any power not specifically handed to the federal government belongs to the states or to the people themselves. If the Second Amendment is the amendment everybody argues about today, the 10th might be the amendment that's been argued about the longest, stretching from the earliest days of the Republic all the way through to modern fights over healthcare, education, and of course, more recently, immigration enforcement. So from blueprint to boundary, if you step back for a second and look at what these 10 amendments actually did to the Constitution as a whole, the original 1887 document was it was a blueprint. It told you how government should be built. It told you how power should move between its branches, how laws should get made. What it didn't do, not explicitly, was tell government what it couldn't do to you. And of course, the Bill of Rights flipped that. It took a document about how the government functions and layered a second document on top of it, one about what government is forbidden from doing, no matter how it functions. Instead of only answering the question, how does the machine run, it actually started answering a very different question. What is this machine never allowed to do to the people living under it? And I think that shift, from blueprint to boundary turned out to be enormously influential, well beyond America's own borders. Versions of it show up in one form or another in constitutions written all over the world in the centuries that followed. And of course, then we come to the promise that took a civil war to keep. And let's just take a quick break, and we'll be back in a second with part 2. Autonomous is your one-stop shop for your Malaysia My Second Home visa. But they are much, much more than that. When you sign up with Autonomous, you become part of a larger community. A community that actually cares about you and your family in Malaysia. And that's important when you move to a new home. For more information, go talk to TG or WhatsApp him on +60 12 49 37 270, or visit their website, penangmyhome.com. And we're back. And I think this is a wrinkle worth sitting with because it surprises a lot of people. When the Bill of Rights was ratified in 1791, it only restrained the federal government. It said nothing at all about what state governments could do in their own state to their own citizens. A state could, in theory, ban a newspaper or seize property without compensation, and the Bill of Rights offered no protection whatsoever because it simply didn't apply there. And remarkably, the Supreme Court didn't even have a final word on what these amendments meant until it claimed the power of judicial review, and that was in 1803. Even then, it would take generations before many of these rights were fully applied across the entire country. That didn't fully change until after the Civil War, when the 14th Amendment was ratified in 1868. And over the following century, the Supreme Court used that attachment to gradually, very gradually, I have to say, apply most of the Bill of Rights to the states as well. One right, one court case at a time. Legal historians call this process incorporation, and it's still not entirely finished, I have to say. You know, a handful of provisions have never been formally incorporated into it at all. And the point is worth pausing on. The rights we now think of as automatic everywhere, all the time, actually arrives in stages, stretched out across nearly 200 years. That then brings me, I guess, to the arguments that never stopped. Here's the part of the story that never really has an ending, because 230 odd years later, Americans are still fighting loudly over exactly what these 10 amendments mean in practice. If you take the Second Amendment, it remains by a wide margin the most divisive of the bunch. Should gun laws be stricter? Which weapons, if any, deserve constitutional protection? Can a state ban certain assault rifles outright? How should mass shootings reshape the way courts read an 18th century sentence about militias? You know, I have to say, few constitutional questions generate stronger emotion on both sides and internationally, and it doesn't look close to settling. Free speech actually carries its own modern twist. The First Amendment restrains what government can do to your speech, but it says nothing at all about private companies. So when the argument shifts to hate speech, misinformation, social media moderation, or protests on university campuses, a lot of the real fight is actually happening in territory the First Amendment was never designed to cover in the first place. And you know, the enormous power private technology platforms now hold over public conversation. Freedom of religion keeps generating its own steady stream of disputes as well. Prayer in public schools, religious symbols on government property, whether businesses can claim religious exemptions from laws that apply to everyone else. You know, the relationship between church and state, sketched out in a single clause, keeps needing to be redrawn generation after generation. The Fourth Amendment might be aging the strangest of all 10, I have to say. Search and seizure law was written for a world of locked doors and sealed letters, and it's now being asked to referee a world where governments can potentially reach into your smartphone, your cloud storage, your location history, and even your biometric data. Courts today are essentially translating 18th century language into a digital vocabulary that nobody in 1791 could have even possessed, even in their imagination. Criminal justice pulls in several amendments at once. You know, the 4th, the 5th, the 6th, the 8th, working together, or sometimes in tension, across arguments over policing, qualified immunity, bail reform, the death penalty, sentencing length, and of course, plea bargaining. And last but not least, there's the 10th Amendment, quietly running underneath everything else. Who actually gets to decide, Washington or the individual states? You know, that question surfaces again and again in healthcare, in education, in environmental regulation, in immigration enforcement. You know, we're seeing that recently. And of course, election administration. something that's never really left the desk since 2016. And of course, more recently, and I think more importantly, reproductive rights. It might be the single most persistent constitutional argument in American history, older even than most of the fights that we've just walked through. So there's an irony at the center of all. And here's the thing worth sitting with as I close. The Bill of Rights exists, I think, because Americans in 1789 were afraid of concentrated government power. So more than 2 centuries later, Americans are still arguing about precisely that same fear, just wearing modern clothes. Nobody seriously disputes that rights matter. That part of the argument is over, and I think it has been for a very long time. What's never really settled is whose rights take priority when they collide with someone else's, how far any single right should be allowed to stretch, and of course, who gets the final word on drawing that line. And I don't think that's a flaw in the document. I think, if anything, it might explain why it's lasted so long. A list of rights that only ever meant one fixed and narrow thing, frozen exactly to 1791, would have aged badly and quietly, the way most 18th century legal texts currently do. Instead, because the language was broad enough to keep things being argued over, every generation has been able to bring its own unresolved questions to the same 10 amendments. Somehow the text has held up under it all. So I talked last episode about the quiet argument running underneath the whole Constitution. Jefferson's belief that each generation should be free to write its own rules from scratch, against Madison's conviction that shared, stable ground was worth more than the freedom to actually keep starting over. The Bill of Rights sits right at the center of that same unresolved tension. The words haven't changed in well over 2 centuries. And yet each generation keeps finding entirely new fights, hiding inside language that was already there, just waiting to be read again. And I think there's a scene really worth sitting with here, because it closes a loop that this trilogy opened with without quite meaning to. In February 1946, a couple of dozen American officials in occupied Tokyo were given 1 week to draft a constitution for the nation the United States had just finalized fighting. And, working under General Douglas MacArthur, a young staffer named B.T. Gordon wrote in freedom of speech, freedom of assembly, protection against unreasonable searches, the right to remain silent, protection from cruel and unusual punishment. It amounts, in the words of historians who have studied it since, to most of the American Bill of Rights, translated into Japanese and handed to a defeated empire. And it actually took effect in 1947. And today, it's still Japan's constitution, word for word, never once amended. Isn't that astounding? Sit with that for a while. A set of protections Madison wrote to restrain his own government ended up, a century and a half later, restraining a government that had, within living memory, been that government's enemy. And it happened at exactly the kind of moment the last episode warned about. A nation whose old institutions had just lost the public's faith completely and had to build new ones from nothing. Jefferson, I think, might have recognized something familiar in that kind of clean break. Madison, well, he might have recognized the caution in how carefully they wrote it all down, rather than leaving it to be argued out later. And I think that's why the Bill of Rights remains both one of the most admired documents America has ever produced and one of the most fiercely contested. Every generation inherits the same 10 amendments. Almost none of them read those amendments quite the same way as the generation before. The Bill of Rights was written because Americans feared that governments left unchecked would eventually take away their freedoms. And how familiar does this sound now? More than 2 centuries later, Americans still fear exactly the same thing. Only now, they often disagree on where the greatest threat comes from. I would argue that it's internal. And perhaps that's the true legacy of these 10 amendments. They didn't actually settle the argument. What they ensured was that it would never end. This episode of Rearview Mirror Chronicles is brought to you by Entrepot Publishing, the home of independent storytelling. We publish books that celebrate history, art, and the extraordinary people who make life fascinating. You can find our titles and maybe your next great read at entrepotpublishing.com. Thanks for listening in, folks. Bye for now.